Your Honor, to aid in argument for the court, I'm going to be addressing the demur regarding count one Rico. And if the court has further questions on the lesser included of the 131, Mr. Abadi's going to address that. Mr. Floyd, if the court regarding the Rodriguez case, which was a case he handled on the demur on the street gang, if the court has more questions on that, and then Ms. Hilton would handle the remaining counts other than count one. I just wanted to give the court that overview.
Thank you.
As the court's aware,
Giving
Your
all of
Honor, the charge as alleged, the conspiracy, the state believes that there has been ample evidence that a rational juror could find that they conspired to commit at least a pattern of racketeering activity. And obviously, defense counsel has focused on the money or proceeds. The state believes that for purposes of directed verdict, the easier one to start with is, which is count 12 of the indictment, and the three criminal objectives as the court outlined in our proposed
12.
page 12 of the indictment, Your Honor.
All right.
That focus on murder, aggravated assault, acts of violence, as well as intimidation of law enforcement and witnesses, which is, I give them numbers in terms of the order of the bullet points. I believe that that's the easier argument or more efficient because there's
Right. I mean, if the state has alleged two different ways of the defendants having violated Rico through a Rico conspiracy, and y'all only have to prove one. You don't have to prove both.
correct,
So
Your Honor.
you're saying there's at least evidence as to the overall purposes, Part B of Rico.
Correct, Your Honor. And a couple things is in terms of that objective of racketeering activity, specifically the murder and the aggravated assaults. You have from the defendant's own words their and tattoos, their allegiance to YSL. I don't want to cite a litany of cases, but there's a number of factors that courts use to establish an enterprise. For example, United States v. Harris, 695 F 3rd 1125 1136 is a 10th Circuit 2012 case, is display of colors. Jewelry, clothing, all of those are just three to start. You also have tattoos, which are permanent. And so Mr. Kendricks has slat on his left forearm and a large snake that was introduced, I believe yesterday or day before, on his stomach that goes up to his neck. You have defendant Stillwell, who has multiple admitted exhibits in post that reference slime or reference his, for example, exhibit 430 VV is defendant Kendrick, overt act 133 with a red bandana and a YSL pendant. State's exhibit 511 VV as admitted is overt act 138 is defendant Kendrick with a hat with a rat crossed out on it. State's exhibit 38 November is overt act 134 where you have Kendrick pointing at the cameraman, two individuals with Make America Slime Again. And I could go on, but the point being you have both 2015 exhibits where Detective Gaither and Detective Dennis, you had Twitters of Mr. Sledge, you had Twitters of Mr. Zachary, Twitters of defendant Stillwell, where multiple, and I'll give a few examples that actively and openly possess my slimes, YSL, this is my brew. And that allegiance coupled with the evidence at trial of the murder of Donovan Thomas to begin with, which captures overt acts 16 through 20, which the evidence of that murder from the interview statement of Kenneth Copeland on June 10th, 2015, and Quindarius Zachary on August 15th, 2015. Quindarius Zachary's interview, which was played for the jury and is in evidence, states that defendant Kendrick and Stillwell confessed to him that very night. And defendant Williams Condo, who rented the Hertz rental vehicle that the Infinity rep, Mr. Thomas Burnett, stated from watching the surveillance video, which I believe is 296 Yankee, that Detective Teague with APD introduced, that was an Infinity Q50. All of those things combined, that statement of Copeland and Zachary for the why, it is a criminal enterprise murder. There's no personal disagreement between Mr. Thomas, Mr. Kendrick, Mr. Stillwell. It is that rivalry of a criminal street gang that weaves through this case. And so in terms of commonalities, it is similar offenses, whether it's victims, the method and mode of operating. In this case specifically, you have a number of incidents that involve multiple YSL self-identified or APD gang detective identified members committing acts of violence together. In Donovan Thomas, you have 4. In Shamel Drinks, you have 4, at least defendant Stillwell, Mr. Garlington in the white Audi, defendant Nichols and Miles Farley in the white Ford Fusion. On the April 28th, 2015, which was Demekion Garlington getting jumped at Club Crucial, there's a 911 call around 2:00 a.m. Fast forward, you have 2 shootings at 1903 Drew Drive and 1428 Adele. You had testimony from Ms. Bell, whose home was shot, crime scene technicians and responding officers, and you had in the interview and testimony of Zachary and Sledge, that act in concert, which was only 3 months after the murder of Donovan Thomas, shooting at, intending to strike rival opposition members, the ABG, Inglewood family, YFN, that group. So from January 10th, 2015 to March 14th, 2022 of the murder of Shamel Drinks, the targeted acts of violence in concert by YSL members is towards the same opposition group. And that's significant for multiple reasons, because as the court knows in Rico, evidence can have multiple relevant purposes to both prove the criminal enterprise and also prove the pattern of racketeering. And I think what is important in this case is, although the state did not allege subsection alpha or bravo of the Rico statute, actual commission of racketeering activity gives clarity that this conspiracy was not some fanciful idea. It was actually alive and well. The best evidence of a conspiracy in a group is a decade's worth of similar victims, methods of operating, and public and active allegiance to this YSL enterprise afterwards that this case and the evidence through testimony and exhibits has established. So the courts, or the state, as a number of other factors, and I will not rattle off all of these cases that are other factors the court looks to an enterprise, gang and hand signs. There's been evidence admitted in testimony from APD gang detectives of the quintessential YSL hand sign, the wiping of the nose, greeting phrases the court has heard and seen in text messages and wiretaps, slat and slime.
Why don't you move on beyond
Yes.
enterprise to some of the other necessary elements?
Yes, Your Honor. So does the court have a specific necessary element that the court would like to hear?
Well, what were you going to talk about next?
Fair enough, Your Honor. So to give structure, moving on from the enterprise, when in terms of agreement or the defendants agreeing to be a part of this, the state's argument, and again, the evidence can have multiple relevant purposes, the tattoos and the public, both association with YSL members and active promotion through either of that criminal street gang through their own words or social media of showing allegiance to that, posting with YSL pennants, using the common gang identifiers and hand signs and with other YSL members throughout from 2015 to as recently as 2022 shows, and the commission of the racketeering activity shows that they were a part of it. As in, you do not need, of course, a written contract. You do not need, of course, some videotaped roundtable of discussion. Their actions speak louder than words. And so if you need to, there's ample evidence a rational juror could find that because of the commission of murder, aggravated assault, and continued association, that they have actively agreed to be a part of this enterprise through their very own actions. You also have October 1st, 2015, where Martinez Arnold gets jumped at Magic City by Kelvin Watts, Shell Kell, who of course has been talked about this week in relation to March of 2022, which shows a commonality. And then he calls Mr. Kendrick, who rides with him, where they get stopped with the multiple firearms in the Trestle Tree area, which there's been testimony from Detective Griffin, who was the lead detective on the Tierra Jones homicide. There's been detective from multiple APD gang detectives about where Summerhill or ABG in that area is where their territory, so to speak. So that action, the January 10th, 2015 murder of Donovan Thomas, however many months later you get to October 1st alone, shows a commitment and an agreement by your very actions, willing to either assist or actively participate in racketeering activity. Furthermore, Your Honor, of course, I think the easiest of this, one overt act committed, and of course, one committed within 5 years of the indictment. The state has, I will use because it's, I believe, one of the most readily assailant overt acts is the murder of Shamel Drinks, which the state believes through the testimony of Viverito, the social media introduced, is a rational juror of fact would find that to be street gang related, enterprise related. Again, there is no evidence of anything other than association with a rival gang that is in evidence of why Shamel Drinks would be murdered for going to pump up his car with gas. And so that act is certainly, it's only a few months before the indictment itself. That alone, the state believes there's been ample evidence that defendant Stillwell has committed that act along with other YSL members, and that alone, a rational juror could find happened and was for, going back to page 12 of the indictment, one of the overlying purposes that the state has alleged, which is important, of preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder. When YSL members were murdered on March 11th, retaliation was needed for the enterprise's reputation and to exact vengeance. And so that overt act alone satisfies. Of course, there is ample overt acts alleged of promoting either the gang itself or violence. I didn't want to run off a litany of admitted exhibits with.
Okay, how about
Yes, Your Honor.
are you going to talk about what the pattern of interrelated racketeering activity within 4 years of?
So, Your Honor, yes. I will take the testimony that has came out related to YFN Lucci or Mr. Bennett, and that is a perfect example of, you have, when Mr. Sumlin testified and the call was presented of Christian Eppinger, who was in the jail, calling him saying, I'm on PC with that boy Lucci, how much can I get for that? Then you have the text messages that were the color-coded charts that Viverito walked through with Khalif Adams, Demikion Garlington, and Jaden Myrick. Then you have the video that from the jail where Jaden Myrick, after that messages about stabbing YFN Lucci, through the testimony of Viverito of what they were discussing, actively tried to stab YFN Lucci. Then you have the post of defendant Kendrick predating that, but 2019, I believe, standing on top of YFN Lucci's.
All right, but I mean, a post isn't an act of racketeering, so talk about.
Yes, Your Honor. So you have multiple YSL gang members, all of which, I use that example because I believe it's so salient, of multiple actors, multiple ages, multiple years in time. It's the same individual that they're trying to exact violence on, who happens to be the same individual who was very close with Donovan Thomas from 2015. All of those, that pattern, the victim and the method of operation, using other YSL gang members,
All right,
create.
so which acts of racketeering activity are interrelated that have to do with that?
Yes, Your Honor. So specifically, you have, let me grab my indictment, Your Honor, so I can see
Sure.
the accurate numbers. Thank you, Mr. Floyd. So in terms of overt act numbers, you have Act 171 as the Eppinger and Sumlin conspiracy to commit murder, which was the jail call, which has been introduced. You have overt acts 165 through 167 is Bobby Hunt, Khalif Adams, Demekion Garlington, Scarface, and Jaden Myrick, which is all related to that February 9th, 2022 attempted murder of Mr. Rayshawn Bennett. And you also have, this is not an overt act, but is quite relevant for this purpose. You know, States Exhibit 227 VVB2 is the text message from defendant Stillwell's phone where he says on February 9th at 7:31 p.m., which is, I believe, within 30 minutes of that stabbing, they just wet Lucci's BITCH up, which again shows an us, a them, a concert, an agreement, a pattern, a method of utilizing contacts through jail, prison, or on the streets to concoct a plan and enact violence on a rival gang, specifically a rival gang leader, who of course on January 22nd, 2015 and January 26th, 2015, mother's house was shot at 1007 Hill Street. You also have the overt act that is in evidence related to the post from defendant Williams of, if I didn't like what you did for your kids and your mother, I would have been killed you, which was about Mr. Rayshawn Bennett, Wyeth, and Lucci. And so all of those things combined, without, you have words in the text messages through somewhat coded language. You have jail calls where Christian Eppinger does mention his name, but you have where they all know what they're talking about, what the goal is. They don't need to go into the agreement and the enterprise's objectives morph into one and the same in terms of without, they don't even, they all have the same common goal of enacting violence on a rival opposition. Is the conspiracy that could be a possibility when I actively join this enterprise is best proven by the attempted murder, and the pattern of racketeering proves the conspiracy was alive and well, in this case for upwards of a decade. And all of those, of course, I use because they're more recent. They're well within the 5 years. Your Honor, I also believe that in terms of an overall pattern, when you have of the 28 defendants indicted, there's many connections in terms of Rodelius Ryan was, I believe, 15 when the murder of Jamari Holmes happened. Roughly, the murder happened early that morning around 4 o'clock. Later on that day, he posted a video of, I bet YSL makes the news. He has Instagram messages that are in where he alleges is quite actively stating FUCKYFN, ABG, right? He would have been 11 years old when Donovan Thomas was murdered. When Wooney Lee testifies about, we put that, what on your gravestone, he would have been much younger. He doesn't come up his name in the murder of Donovan Thomas, but the fact that members who either have, actively promoted, tattooed, claim allegiance to this enterprise of different ages, of different times, have the same enemy, the same disagreement through racketeering activity in its truest sense of violence, is the similarity, is certainly for a rational trier of fact to find that there is a clear common interwoven theme, which I use the violence because, again, I believe it's the most salient of this point for purposes of directed verdict.
All right, can you speak to whether it matters that the indictment itself doesn't contain the language willfully and knowingly?
So, Your Honor, Mr. Floyd was going to address that
Oh,
much more eloquently
okay,
than
all right,
I,
that's fine.
if that's all right, but with the
Okay,
court.
thank you, I appreciate it.
Yes, Your Honor. Yep.
And you're going to do that for the RICO and the gang counts, the language,
Yes, Your Honor.
Mr. Floyd? Okay.
Thank you. That's what I needed. Yes, sir. Okay. Your Honor, first, what was characterized, I think, as a general demur argument, or an argument that included general demur,
Right.
I listened to it and it was very familiar. It was very familiar because it was made and rejected over 2 years ago in the same case. The Ruan case, to which reference was made, is a United States Supreme Court case. It is not a RICO case. It is nothing like a RICO case. It was a case that involved the federal prosecution under the Federal Controlled Substances Act of doctors who had basically signed pill mill prescriptions, and the application of a federal regulation to that circumstance dealing with the validity of those prescriptions. So not on all fours, not on all threes, maybe not even on all twos. The important thing that matters is the statute. First of all, the text of the statute does not make reference to knowingly and willfully. And so the charge is in the language of the statute, which is sufficient. I mean, that's pretty much the end. That's pretty much the end of that argument. To the extent that the argument blurred into kind of a special demur argument, the point is that first, every defendant is charged with conspiracy. There's no question about who's charged and who's not. It's very clear. It's charged in the language of the statute. Every defendant is alleged to have actually committed acts of racketeering activity. Those require a certain level of intent, and that is proof of the level of intent sufficient to commit a racketeering activity act of racketeering activity has been held sufficient to sustain a RICO conviction by the Georgia courts. They've said there isn't another layer above that. If you have the intent to commit the act and you commit the act, that's sufficient. Page 60, most of this is laid out on page 12, but also of the indictment, but also if you go to page 68, which is at the end of the overt acts, you'll see that we have specifically alleged they were committed in furtherance of the conspiracy, tying every act to that conspiracy, and therefore every individual who committed one of those overt acts to a conspiratorial agreement alleged above that they had the same or similar, which is the test under the statute for relationship. Similar is sufficient. Intents, results, accomplices, victims, or methods of commission, or otherwise were interrelated by distinguishing characteristics. I think Mr. Adkins has well covered that component of it, but it is also specifically alleged here.
Okay, that's page 67 of the indictment.
68.
67 of mine.
Oh, okay, sorry. You probably have you have the deluxe version. At any rate, it immediately follows the last predicate act. So that'll help us all navigate. The point though is that, and this is as true of the Gang Act as it is of this, the cases that have said knowingly and willfully, or the cases that talk about what has to be proven, are not pleading cases. They're not general demur cases. It's just a question of what does the state have to come forward with. Neither statute says knowingly and willfully. Rodriguez is familiar to me. I briefed Rodriguez. Mr. Carlson and I argued Rodriguez. Rodriguez was a facial constitutional challenge. It had nothing to do with the sufficiency of pleadings. And it simply interpreted the statute in light of a vagueness challenge. So not close to being on all fours with this situation. There is no Georgia case of which I am aware that says the state has to allege knowingly and willfully. It's purely a question of proof. That takes us to the directed verdict standard, which is simply, could a rational juror find that these defendants acted knowingly and willfully? Most of the argument on that was simply the defense's interpretation of the meaning and weight of the evidence, which is not a permissible consideration in this analysis. The court does not resolve, cannot resolve those issues. And for a case that's directly on point on that, that is the Evans case, which I believe I cited to you yesterday. It's the other APS appeal along with Cotman, and it lays out the standard in the specific context of a directed verdict or motion in a RICO conspiracy case. And the standard that it enunciates is exactly the same
I
as,
think you cited that yesterday. Can you give
okay,
me
I'm
that
sorry,
site?
it's Evans v. State. By recollection, it's a 2019 decision. I don't have it immediately in front of me, but there's only going to be one Evans RICO APS. There it is. It is 360 Georgia Appeals 596 at 600. The court said the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And thank you. And just since I'm up, the question of, I guess I'd call it the more than one overt act being alleged, more than the jury seeing more than one overt act. I mean, the logic behind that is kind of topsy-turvy. If you think about it, there's nothing that requires the state to plead the barest minimum in an indictment. And in fact, generally to do so, we would draw a wave of special demurs. Even with this indictment, we drew special demurs with as much
Right, so
detail as it has.
At this point, they're not any longer challenging what you put in the indictment. They're saying whether it's in there or not, it shouldn't be out with the jury for their consideration.
Well, that comes down to if I understand correctly, an argument that there's not sufficient evidence for the jury to find the defendants acted knowingly and willfully, and that is clearly present.
Oh, no. I think we're interweaving
I'm sorry,
different
then,
issues now. I thought you were moving on to the issue of whether overt acts that aren't within the 5 years.
Paige messed that up, not him.
and indeed, I
Yes,
have.
it was definitely okay to put them in the indictment, whether they should go out with the
Yeah,
jury.
okay, I
If
understand.
you weren't, then bring me back to what.
No,
we
I
were
may have,
talking
I may
about.
have ground the gears a little bit on that
Okay.
one. But I think I just want to make sure you don't have any more questions about the knowingly and willfully issue. And if you don't, then I'll move on to that question.
Okay.
If I understand the logic chain from the defense, it is basically, we only have to prove one overt act within 5 years of the date of the indictment. Therefore, anything else is, I think the term was used, surplusage. That doesn't fit the definition of surplusage. And then with particular emphasis, they've said if it's outside of that 5-year window and then would not be relevant to prove the timeliness of the indictment, that then particularly the jury shouldn't hear it because it's confusing, et cetera. I'm aware of no case that has accepted that argument. And it shouldn't be accepted because the allegations are relevant. They show the existence of the enterprise, right? This is, this begins, it begins a long time ago. The state is not precluded from charging or presenting evidence that shows this enterprise has existed for a long time. I mean, at the kind of the extreme level of this, there are federal RICO indictments involving the 5 families in New York that discuss the entire history and formation of them going back to the Castle Amorisi War of 1932, I think it is. So they would now span almost a century. That was not irrelevant because it tells you how this enterprise came to be, and it shows the early participation of certain individuals. It shows its longevity, its consistency. I mean, under the law, enterprises don't have to be in operation 24 hours a day. They can have lulls, et cetera. But where they continue to exist, where the people who participate in them continue to acknowledge their existence, that is certainly relevant. And there's not an arbitrary cutoff where the indictment gets trimmed to match the statute of limitations. I'm just not personally aware of any case that's ever done that.
Okay.
Thank you.
May I respond briefly?
Well, I mean, we're still in the middle of the state's presentation, so yes, y'all both get,
Fortunately.
since it's your motion, a chance to reply, but not right now.
Good morning, Your Honor. I'll be addressing the directed verdicts as to count 2 and 49 of the indictment, which are the murder counts. Count 50, 51, and 57, which are the participation in criminal street gang activity. Counts Mr. Floyd, whenever the court's pleasure, will address the general demur as to the participation in criminal street gang activity.
I mean, Mr. Floyd, did you have anything, I mean, I took your argument to be essentially, you know, the knowingly and willfully as it applies to Rico, and then basically apply the same argument with regard to the in furtherance of the gang, with regard to the gang counts. Did you have anything to add to that?
Not really, Your Honor. The statutes are quite similar on this point. Historically, the Gang Act is actually kind of a linear descendant of RICO, that some states didn't want to enact a full RICO. They just enacted a gang statute. We enacted both. They have slightly different elements, but on this principle, there's really no difference.
Thank you.
Thank you.
And then I'll be addressing count 62, possession of a machine gun. And then count 52, 64, and 63, which are the possession of firearms by a convicted felon.
All right,
Those are some of the ones
52
with the
isn't
issue.
133, right?
No, Your Honor. 133 will be count
63 and 64.
63 and 64, Your Honor. So, Your Honor, as Mr. Floyd just enumerated, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt, and that's cited in Evans v. State, 360 Georgia Appeals 596, which is the 2021 decision. And first, we're going to start with count 2, the murder of Donovan Thomas Jr., Your Honor. The state has presented evidence that we believe will be sufficient for a rational trier of fact to review in the light most favorable to the prosecution. Your Honor, we have presented evidence of the June 10th, 2015 video recorded interview of Mr. Kenneth Copeland at the Atlanta Police Department, which is Exhibit 378, Yankee Echo. In that video, Your Honor, Mr. Copeland discusses a co-conspirator statement of Demekion Garlington, in which Demekion Garlington tells him about the murder of Donovan Thomas, that who was involved, which was Mr. Stillwell, Mr. Kendrick, Mr. Justin Cobb, Mr. Damas, and Mr. Damas McMullen. In that interview, Mr. Copeland speaks of his whereabouts on the day of the murder of Donovan Thomas, beginning on early in the morning hours, and when he eventually meets up with Mr. Garlington at a gas station on Cleveland Avenue. He further tells the detectives that Mr. Garlington told him that those 4 individuals, again, Mr. Stillwell, Mr. Kendrick, Mr. Cobb, and Mr. McMullen, had committed the homicide of Donovan Thomas Jr. He told them about the type of car that they were in, which was an Infiniti vehicle, the location of where Mr. Donovan Thomas was, which was the barbershop on 330 McDaniel Street. We then also introduced the August 2015 statement of Quindarius Zachary, which was State's Exhibit 531Y, which Mr. Zachary corroborated some of the same information that Kenneth Copeland provided. He also added the additional information or evidence in that interview, which was Mr. Stillwell and Mr. Kendrick at the condo of Jeffrey Williams confessed to him that they had participated in the murder of Donovan Thomas Jr. Those statements and the detail of those statements are corroborated by certain other evidence that has been admitted. We have the barbershop surveillance video, which is at 292 Yankee Alpha through 292 Yankee Delta. That video surveillance showed Mr. Donovan Thomas Jr. outside the barbershop moments before a silver and color vehicle, which was identified in testimony as an Infiniti, drove down the street and shot several rounds of gunfire
Rounds.
towards the direction of Mr. Donovan Thomas Jr. We also have the Texaco surveillance video, which corroborated Mr. Kenneth Copeland's statement. In his statement, Mr. Copeland tells officers that Demekian Garlington told him that they met at the Texaco gas station, that they switched cars, which he explained that Mr. Kendrick initially arrived in a Pontiac Bonneville, and that the gray Infiniti vehicle met at the Texaco gas station. That was depicted on the surveillance video. In the surveillance video, you see Mr. Kendrick walk into the gas station. You see Mr. Kendrick approach a silver Infiniti vehicle. You see both of those vehicles leave out of that gas station at the same time. Your Honor, yes, what we do not see is when the transition occurred between Mr. Kendrick getting out of the Bonneville and getting into the Infiniti, but we believe that's a reasonable inference that happened off camera outside of, we believe, behind the Texaco gas station. Mr. Copeland also discussed in that interview that the car that they used was rented by Mr. Jeffrey Williams. We were able to admit State's Exhibit 334Y, which was the rental agreement from Hertz Rental, which showed that the vehicle was rented by Mr. Williams about 2 days before the homicide of Mr. Donovan Thomas Jr. We then also have phone records that corroborated what Mr. Copeland said. We have the phone records that showed that when Mr. Copeland woke up in the morning hours, or the afternoon hours, of January 10th, 2015, he was located, he told police he was at his girlfriend's home, which was in the village of Carver Homes. The phone records corroborated that his phone was at that location at that time. He then proceeded to tell officers that from leaving his girlfriend's house, he went to the green store. The phone records corroborated him going to the green store. The phone records then corroborated what he told police, that he then went to the McDonald's the McDonald's restaurant, and that's where he met with Demekian Garlington, and that's when Demekian Garlington explained to him everything that occurred. Mr. Copeland was also able to tell the police that Mr. Demise McMullen actually was at the McDonald's when he arrived, and when he met with Mr. Garlington. The phone records corroborate that Mr. McMullen actually made contact with Mr. Williams about 6 minutes after the murder of Donovan Thomas. Immediately following the phone call with Mr. McMullen, there is a number of different phone calls to a variety of different people, specifically an individual by the name of Kelvin Treadwell, O.G. Bentley. Both Mr. Copeland and Mr. Zachary, in their statements, advised that after the murder of Donovan Thomas, that the guns in the vehicle were given to Kelvin Treadwell, also known as O.G. Bentley. The phone records corroborate that a number of different phones, Mr. Williams' phone, Mr. McMullen's phone, all ping in the location in and around near Kelvin Treadwell's home after the murder. Their phones ping off of the tower closest to Mr. Treadwell's home. So that evidence has come in, Your Honor. We have the autopsy photos that show that Mr. Donovan Thomas was murdered and killed with certain types of shell casings. Your Honor, we have the jail call of Mr. Stillwell. I do not have that exhibit number, which was entered after his preliminary hearing, Your Honor, in which at the preliminary hearing, we know from both Investigator Thorpe and Deputy District Attorney Michael Sprinkle that during the preliminary hearing itself, they didn't use any names. They used witness number 1, witness number 2. However, on the jail calls that we have both with Antonio Sledge and Mr. Stillwell, that they identified one of the witnesses being Little D. Little D was the other name was the nickname for Quindarius Zachary. And what Mr. Stillwell said during that call is, they snitched on me. And I'm paraphrasing. It was never, they lied on me. There was never any other language, but we have that evidence. We have that in evidence. We also have in evidence, Your Honor, State's Exhibit 477NN, which is the slat talk video in which Mr. Stillwell says the words, "I just beat a murder rap, pay my lawyer $30 for that." Also, he has we introduced more recently another song that Mr. Stillwell has, which was called BS or Bullshit. And in that song, he says, "Beat the harm, no evidence." We believe that that is another reference to the murder of Donovan Thomas. We also have State's Exhibit 436 VV, which is Mr. Stillwell after in 2019 posting a picture with himself in a slime sweatshirt with the peanut gravestone in Spanish, then immediately deleting that from that Instagram post within a few minutes after posting it, Your Honor. So we believe that there is sufficient evidence for the jury for a rational trier of fact to be able to find the essential elements of the crime beyond a reasonable doubt. Next, Your Honor, I will go to count 49, the other murder count in this indictment, Your Honor. Your Honor, the state has admitted crime scene photos of the crime scene at the time. That's going to be State's Exhibit 65, Victor Victor through 115, Victor Victor, specifically 79, Victor Victor has Mr. Shamel Drinks deceased inside of the car.
We definitely know he's dead.
Yes, inside of the car. We then have, Your Honor, the surveillance videos from, specifically, I'm going to focus on the BP surveillance video, which is State's Exhibit 116 BV, and the FedEx surveillance video, which is State's Exhibit 117 BV. In both those videos, Your Honor, initially, before we know who was identified, we see a white, extremely darkly tinted Audi vehicle come to the gas station. We also see a white Ford Fusion. We see individuals from those two vehicles enter into the gas station. We later learn that that is both Shannon Stillwell, Quarmavius Nichols, and Miles Farley. We have the evidence that in that same surveillance video, within 5 to 7 minutes after they are at the location, Mr. Drinks arrives at their location in his red vehicle. He is seen walking inside of the store. That surveillance video then shows that when Mr. Drinks' red vehicle leaves, very soon thereafter, both the white Audi that's tinted leaves the location, as well as the white Ford Fusion. We do have a wiretap telephone call, which is State's Exhibit 437 VV. The call, I can't recall the page number at this time, Your Honor, but the call that is at 9:59 p.m. based upon the wiretap data, which is a call that tells from Demekion Garlington telling another occupant of the white Ford Fusion to immediately get on FaceTime, Your Honor. There's evidence from even Mr. Demekion Garlington's wiretap where they talk about getting on FaceTime when they don't want to discuss certain things on the phone. We also heard that from expert witnesses that FaceTime is a mechanism that is used when criminal activity is going to take a foot because it cannot be tracked. At 9:59, that call takes place. We then see on the FedEx surveillance video at approximately 10:01 p.m., Mr. Drinks arrives at the lights, as well as the white Audi, as well as the white Ford Fusion. The white Audi and the Ford Fusion stay at the light for approximately 2 minutes, Your Honor, before they take off into traffic running the red lights. Your Honor, at that time, the red vehicle never moves again. We see from the ankle monitor records, Your Honor, based on the evidence that was provided in the ankle monitor records, that within a minute, Mr. Stillwell's ankle monitor goes from 18 miles per hour to 90 miles per hour. We know from the phone records that both cars travel in the same direction towards Fulton Industrial Boulevard, where we believe they go to a music studio. We then have from Mr. Stillwell's phone, a phone note in which, I'll paraphrase, he talks about dropping the ops. Very soon thereafter, and that is right after Mr. Drinks is at that light. We then have, Your Honor, again, phone records that put both Mr. Stillwell, Mr. Farley, Mr. Nichols all in the same area, which is the area of the gas station in and around the same time. Your Honor, we have social media posts. Oftentimes we don't have motive, but we have social media posts in this case that were posted between March 11th, 2022 and March 15th, 2022. One, we know that on March 11th, 2022, the evidence showed that 2 YSL associates were murdered on a highway, both Mr. Christian McMiller and Mr. Darius Ford. And we have in evidence, State's Exhibit 452 VV, which is a post from Mr. Stillwell. And I believe this post is on March 11th or maybe March 12th that says, "Just rest, Mac, I got you." Then we also have a post, which is 458 VV, that is posted on March 11th with Mr. Stillwell posting, "I ain't gonna be the only one crying." Then on March 15th, 2022, we have Scarface, who is, we believe, in the car with Mr. Stillwell at the time that the murder takes place, posting a picture of both Mr. McMiller and Mr. Ford saying, "We got y'all boys." And that is only hours after the death and murder of Mr. Shamel Drinks. We then also introduced, Your Honor, the rental car agreement, which showed that Mr. Stillwell rented this vehicle on March 14th, 2022. And then we also have the wiretap information that shows that he went to a tinted window car place and got deep tinted tints on this car on the day that this occurs, Your Honor. And then we have text messages while in January of 2022 saying that he goes op hunting. So, Your Honor, we believe that that evidence is, quote the right language, that evidence is evidence that a rational trier of fact could find the essential elements of the crime of murder beyond a reasonable doubt. Next, Your Honor, I will go to count 50 and 51, which are both the participation in criminal street gang activity as to Mr. Shannon Stillwell, and then count 57 as to Mr. Diamante Kendrick. Mr. Atkins touched on this somewhat, but I'll just add some additional evidence that has been presented. We have the testimony from investigator Mark Belknap, Trontavia Stevens, Walter Murphy, Antonio Sledge. Well, sometimes it was easy to get out, sometimes it wasn't, but they all have said that YSL is a gang. We have evidence of the tattoos of Mr. Kendrick, which was 518 VV to 520 VV, which—
Before you do the gang counts, can
Yes.
you address the 58 through 61 drugs and machine gun, and whether there's evidence of constructive possession for Mr. Kendrick?
Yes, Your Honor. So first with the possession of machine gun, which is count
62, yes, sorry.
One, just the proof that of the gun itself, we have the—
I know that that's established.
Okay, so as regarding Mr. Kendrick, Your Honor, there is evidence that we know from his phone that he had been at the home earlier that day. We know that based on testimony from Officer Samba, that he fled from the home
No, he was, okay.
and apprehended, Your Honor, and we believe that that would be some evidence of consciousness of guilt, the fact that he fled before the police even, I think, hit the door of the home, that he had fled out of the home, Your Honor. We believe that inside of the home, there were a number of guns, both from the pictures, you can see that there's a number of guns outside on the kitchen table. There were some guns.
Remind me where the machine gun was found?
The machine gun is actually downstairs, we believe, in the basement of the home by, underneath
Laying
the
on the
couch.
floor?
Yes, laying on
Yeah,
the floor
okay.
underneath the couch, Your Honor. It is the state's theory, Your Honor, that when the SWAT team did not make a quiet announcement to get, to come into the home, and it is the state's theory that when the announcement was made, you could tell from some of the images, we believe that there was an effort to hide some of the items that were inside of the home. This gun was kind of maybe kicked underneath the couch where you had to pull it looks like they pulled the couch back in order to observe this gun that was actually in the basement, Your Honor. To address the drugs, Your Honor, which are counts 58 through 60, which is the possession of marijuana with intent to distribute, the possession of codeine, and the possession of cocaine, Your Honor. I believe all of these items, which was Stacy Exhibit 12XX, 17XX, and 18XX, the marijuana, I believe, was out in the open. If my memory serves me correct, I need to pull up the picture again, but I believe that the marijuana was out, present, and open in the home, Your Honor. That specifically 18XX was not hidden. 17XX was the marijuana with guns that was found in a cabinet, I believe above the refrigerator inside of the kitchen of the home. And then the codeine, if you give me a moment, I just want to pull up the picture so I can make sure I know where the codeine was found
They
inside.
were like in a box in a closet, right?
I believe they were, but I thought that there was some that was out as well. But of course, indulgence.
Court's indulgence. Yeah, the kicking thing is new to me, and I'm just laughing because Viverito found out that Yak played football yesterday or whatever. So, like, is this just like a new thing they're coming up with? It's just such a narrative. Like, they're always adding a narrative. Same thing with the witness number 1, witness number 2. Sprinkle was just on the stand saying that at preliminary hearings, they use initials for witnesses. So if I say QZ at a prelim, for example, maybe I think that they're talking about Quindarius Zachary, right? That's different than witness 1, witness 2.
In the closet and then in a bathroom upstairs in the house. And then the cocaine was found in the pantry as well. In that same bag, there was a bag that had in the pantry that had the cocaine and the cocaine and the codeine, Your Honor.
And the marijuana was out where, in the kitchen?
So there's one in a Tupperware container that's in the, on the kitchen counter, and then there's the bag of marijuana that was in that cabinet with the gun
Right.
that's in the cabinet above the, I think, the refrigerator.
Was there any evidence presented that Mr. Kendrick was like staying there as a residence, or just that he was there that day?
No, Your Honor, the evidence that we have is that he was present that day, and we believe that he had been present maybe a few days before.
But not continuously?
Not continuously, no, Your Honor.
And so can you address constructive possession?
Your Honor, it's just the state's position that at the time of Mr. Kendrick being at the home, that he had knowledge of the drugs being present in the home, Your Honor. Specifically the marijuana, Your Honor, as well as the guns being in and around the home.
He's only charged with a machine gun, right?
He's charged with the machine gun, and he's charged with
There are like 4
possession
or
of a firearm
5.
during a commission of felony with all the other guns that were found inside of the home, Your Honor. So he's charged
That's
both,
the count. Which
That's-
count is that?
yes, Your Honor.
That's count 63.
Yeah, so count 62 is a machine gun and count 63 is possession of firearm by convicted felon for the other, in addition to the machine gun, the other guns found inside.
Where are
the
all
home.
of those found? Remind me if you don't mind.
Yeah, they're found in different locations. So I believe the FNH 57, I don't, so 13XX, Your Honor, the FNH 57, and that's found on the kitchen counter behind like a green dinosaur. And then there's the two firearms.
Can you
which is-
show me a picture of that? Let me join Zoom.
I'm logging into the Zoom now.
Yeah, I am too.
So, Your Honor, this is.
Wait, I don't remember this.
H57.
Why are we showing stuff now?
Area,
All right, those are just sitting out on the counter, right?
yes.
All right.
And then
That's in the cabinet.
that's the.
That's
two-
above, yeah.
Yes, Your Honor,
So a lot of this looks like it's documenting what the guns are. I just want to see the ones that show where they were found.
so these are two more.
Those are in the cabinet.
Those are in the
Up
cabinet.
above, yeah.
This is the pantry, Your Honor, where this other gun was found.
That's like the, I think somebody referred to it as like the hidden
Yes. It's.
door or something like that.
Yes, Your Honor.
And that's where the codeine's found too?
Yes, Your Honor.
And the cocaine?
Yes.
Okay.
And then this is where this is where the machine gun is found, Your Honor.
That's after the couch is moved or after it's,
Yes, Your Honor.
any idea where, do we have a picture of the couch before it was moved?
No, I don't think so, Your Honor. I think once they moved it and found it, they took a picture of it.
Okay.
Couldn't get a still from the body cam.
All right, thanks. All right, and then you were gonna circle back to,
Your Honor, I guess there's one more gun to be shown.
okay.
And there's one found in the upstairs bedroom.
Whose bedroom is that?
We believe this is, the room. We think that the ID for Jimmy Winfrey was found in this room.
For who?
Jimmy Winfrey was found
Okay.
in this room.
All right.
Go back to the gang count, Your Honor?
Yes.
Okay.
And address Mr. Kendrick's count first, which is 57.
Your Honor, it's the state's position, Your Honor, that the drugs inside of the home were all, specifically the possession, the codeine, Your Honor, as well as the marijuana with the phone counters were being prepared for distribution. If you remember, there was the large pail of codeine that was found, a number of different bottles being found, Your Honor. As you also saw, although not charged because it's not illegal, was the YSL drink juice that was inside of the home, Your Honor, which looked like that was being packaged for some type of sale or distribution of itself, Your Honor, that these particular drugs were possessed in furtherance of the criminal street gang to sell narcotics, Your Honor, to sell both marijuana as well as to sell the codeine. We have evidence of the money counter inside of the home, Your Honor. Mr. Kendrick was at the home, was present at the home. There are a number of different guns present inside of the home, which we know guns are usually kept with drugs in the sale of drugs, Your Honor. And so based on that evidence, we believe that there's sufficient evidence to go back to the jury to show, at least for that count, participation in criminal street gang activity, given that evidence that has been admitted into evidence, Your Honor.
We didn't have any evidence as to like the weight of the cocaine or anything like that, did we?
Yes, I believe the GBI did,
Okay, maybe y'all just didn't highlight that.
yes.
But that wasn't a,
That's not an intent to
that wasn't a
distribute.
distribution
No,
amount.
no,
Okay,
that's
right.
simple
right.
possession.
And if it's simple
And Your
possession,
Honor, specifically regarding the guns, because we also charged count 57 with the guns. The state believes that they were still in the midst of a gang war. This was only 2 months after both Mr. McMiller and Mr. Ford had been murdered. There had now been the retaliatory shooting of Mr. Shamel Drinks. We know that 2830 Waters Road had been shot at multiple times. And so we are now still in the midst of, or we believe, a gang war. And with that amount of guns and weapons inside of the home, a machine gun, Your Honor, that these were tools, whether it was to protect themselves or get ready to go and continue war, that they had this ample amount of firearms inside of the home, all in furtherance of this gang war that we believe is still going on even to this day, Your Honor.
is that it?
All right, moving on to Mr. Stillwell's other counts.
Yes, I believe Mr. Stillwell's count that I have not addressed yet are participation in gang activity, which I believe
Oh,
Mr.
yeah, save that one to last. Let's talk about the underlying ones first,
Okay.
if you don't mind.
So I believe his next count is possession of a firearm by a convicted felon and possession of a firearm during the commission of a felony, Your Honor. I believe those are the last two.
Okay, hang on then. So
And I will address the possession of a firearm during the commission of a felony, and then Mr. Abati will address the 133 possession of a firearm by a convicted felon.
Give me a second. I'm sorry, they're kind of not all together in the indictment. I
No
wanna make
problem,
sure
Your Honor.
of. All right. Go ahead.
Okay, so for count 54, Your Honor, possession of a firearm during the commission of a felony, Mr. Drinks was killed with, I believe, a 40 caliber, I believe a Glock handgun based upon the GBI testimony that came in. Your Honor, there was testimony yesterday from Investigator Viverito that in a video that's was created about an hour before the murder of Donovan Thomas, that there is a gun that could be consistent with a Glock 27, which is a 40 caliber handgun. That is the evidence that we have, Your Honor. We never recovered the handgun used in this case, Your Honor, but there is evidence. I believe if we look back to the Donovan Thomas murder, that after that murder, they got rid of the gun. It's the state's theory that the same thing occurred in this case, that after the murder of Mr. Drinks, that they did get rid of the Glock handgun that murdered Mr. Thomas. But we do know that Mr. Drinks, but we do know he was killed. It is the state's theory that Mr. Stillwell shot and killed him, and would have shot and killed him with a 40 caliber handgun, Your Honor.
Is it him or Garlington?
All right, and then the other gun one was the one that was tossed or that.
Yes, Your Honor, and then we know from Miss,
Right before they were arrested.
right before that, I'm sorry, that's count 60,
Okay, that was registered to,
Miss Taisha Alexander, Your Honor.
all right.
And I do believe for the gang, Your Honor, Mr. Adkins discussed that within the Rico, when he talked about
Okay.
the gang, so,
Thank you.
thank you, Your Honor.
All right, reply argument.